morning, class 8th. Welcome to your history and civics class. We are doing lesson number 3, the Indian judiciary. Let us see the objectives that we have covered in our previous video. We have studied about the Supreme Court, Chief Justice of India and other judges of the Supreme Court, their qualifications, tenure, power and functions of the Supreme Court, and under the power and functions of the Supreme Court, we have studied original jurisdiction, appellate jurisdiction, advisory jurisdiction, supervisory jurisdiction, revisory jurisdiction, court of record, and judicial review. All these were the important functions, powers, or we can say jurisdiction powers of the Supreme Court. Just focus on these important terms and try to give the answers. Number 1, Supreme Court. Number 2, Appellate Jurisdiction. Number 3, Original Jurisdiction. Number 4th, Jurisdiction. 5th, Collegium. 6th, Writs. Number 7, Court of Record. Number 8, Criminal Cases. Number 9, Civil Cases. Learn these terms. These are few cross questions which are prepared for you. Try to give the answers of these as well. Number 1, how is the Chief Justice and the other judges of the Supreme Court appointed? Number 2, over which cases does the Supreme Court exercise appellate jurisdiction? Number 3, what are the differences between civil and criminal cases? Next question, what is the tenure of the judge of the Supreme Court? And the last question, what are the qualifications required to be a judge of the Supreme Court? Alright children, now these are the topics that we have to understand today. Number 1, the High Court, jurisdiction powers and functions of the High Court, original jurisdiction, appellate jurisdiction, supervisory jurisdiction and revisory jurisdiction of the High Court, and of course the most important topic, that is the writs and its types. Before moving ahead with our topic, let us see the technical terms that we will learn today. Number 1, the High Court. The highest court in a state is known as High Court. Number 2, Court of Record. A court of record is a court whose acts and proceedings are printed and kept in record for future references in the court. Number 3, writ. A writ is a formal written order issued by a court. It can be Supreme Court or the High Court of India that requires specific action by the person or entity to whom the writ is directed. Next term, original jurisdiction. The cases that come directly to the Supreme Court or High Court without being taken to any other court fall under jurisdiction. And the last term is appellate jurisdiction. Appellate jurisdiction is an appeal against the judgments of the lower courts. The Indian High Courts Act of 1861 was an act of the Parliament of the United Kingdom to authorize the Crown to create high courts in the Indian colony. Queen Victoria created the high courts in Calcutta, that is present-day Kolkata, Madras, present-day Chennai, and Bombay, present-day Mumbai, in 1862. The act was passed after the First War of Independence of 1857. High Court usually refers to the superior court of a country or state. In some countries, it is the highest court, for example, Australia. In others, it is positioned lower in the hierarchy of courts, for example, England and India. A person who presides as a judge in such a court may be called a High Court judge. There are 25 high courts in India. As you can see clearly in the map, the red dots representing the High Courts of India and one blue dot there in New Delhi represents the Supreme Court. The total number of judges sanctioned in these high courts are 1079, of which 771 judges, that is 771 judges, are permanent and remaining 308 sanctioned for additional judges. Why are the additional judges appointed to the High Court? Children, if there is any temporary increase in the business of the High Court and the President feels that the number of the judges of that court should be for that time being increased, then he may appoint duly qualified person to be additional judges of the court. The High Court is the supreme judicial body in a state. According to Article 214, Each state of India shall have a high court. However, Article 231 also mentions that there can be a common high court for two or more states or for two or more states and a union territory. There are 25 high courts in India, 6 having control over more than one state, union territory. Delhi has a high court of its own among the union territories. For example, the Guwahati High Court has jurisdiction over Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, and Arunachal Pradesh. Bombay High Court has jurisdiction over Maharashtra, Goa, Dadar and Nagar Haveli, Daman and Diu. Kolkata High Court has jurisdiction over Kolkata and Andaman and Nicobar. Kerala High Court has jurisdiction over Kerala and Lakshadweep. Madras High Court over Madras and Puducherry, and Punjab High Court has jurisdiction over Punjab, Haryana and Chandigarh. Composition of High Court. A High Court consists of one Chief Justice and many other judges as the Parliament may fix from time to time. Besides, the Chief Justice of a High Court can call any judge from the subordinate court to serve in the High Court temporarily if the load of work so demands. A temporary judge can be appointed for a period of not more than 2 years. Temporary judges are also known as the additional judges. Number 154. Let us do the reading of the High Court. Introduction. The highest court in a state is the High Court. Usually, each state has a High Court. Sometimes, two or more states and union territories have a common High Court. For example, Chandigarh High Court has its jurisdiction over the states of Punjab and Haryana and also over the union territory of Chandigarh. Jurisdiction means the extent of the power to make legal decisions and judgments. At present, there are 25 high courts in India. Children, please correct the number from 24 to 25. A high court consists of a chief justice and a number of other judges. Children, let us understand that how the number of the high courts has been increased from 24 to 25. With the enactment of the Andhra Pradesh Reorganization Act of 2014, Andhra Pradesh was bifurcated into two states, that is Andhra Pradesh and Telangana. Bifurcation means the division of something into two branches or parts. Since the bifurcation of the state on June 2014, Andhra Pradesh and Telangana have had a common high court situated at Hyderabad. The Act, which had come into effect from June 2, 2014, had also a provision for separate high courts for the state of Telangana and the state of Andhra Pradesh. Hyderabad, which was the capital of Andhra Pradesh, is now a part of Telangana and became its capital. The existing High Court is located at Hyderabad and it would be having the High Court of State of Telangana. Insofar as state of Andhra Pradesh is concerned, it has been decided to create and construct a new city known as Amravati, which is going to be the capital of the state and the new High Court of Andhra Pradesh. The Chief Justice as well as the other judges of the High Court must possess certain qualifications like he must be a citizen of India. He must have worked as a judge in any court in India for not less than 10 years, or he must have worked as an advocate in the High Court or High Courts in India continuously for 10 years. Tenure or condition of services of the judges. In order to ensure the independence of the judiciary, even in the states, it has been provided that once appointed, the Chief Justice and the other judges of the High Court shall continue to function till they attain the age of 62 or they themselves resign their office. The procedure of their removal has been made very difficult. They can be removed by the President only upon a joint address by both the houses of the Parliament. But such an address must be passed by a majority of the total membership of both the houses and also by 2/3 of the members present and voting. Undoubtedly, this is a very difficult procedure. Thus, the position of the High Court judges has been as independent as possible. Sumitra Sen is a former judge of the Calcutta High Court. He was the first judge in independent India whose removal motion was passed in Rajya Sabha for misappropriation of funds, and he became the first judge to be impeached by Rajya Sabha. Appointment of the judges of the High Court. The Chief Justice of a High Court in India is appointed by the President in consultation with the Chief Justice of the Supreme Court and the government of the state concerned. The judges of the High Court are appointed by the President after duly consulting the Chief Justice of the concerned High Court. The Governor administers the oath of office to the High Court judges. Children, can you answer? Who is the Chief Justice of the High Court of your state? Leave your answers in the comment box. Let us continue the reading on the same page, 154, eligibility and then tenure. Eligibility means qualification. To become a judge of a high court, a person must be a citizen of India, have held a judicial office in India for at least 10 years or have worked as a judge in any court in India for at least 10 years. Judicial office means it is a term relating to the administration of justice. Next, must have been an advocate of a high court or two or more such courts in succession for at least 10 years. Every high court shall be a court of record according to Article 215 of the Indian Constitution. Tenure. Judges of the high courts are also appointed by the President. Once appointed, the judges remain in office till the age of 62 years. A judge can resign earlier by submitting her or his resignation to the governor or can be removed by following the same process as that in case of the judges of the Supreme Court. Children, just like the Supreme Court of India, a High Court also has vast powers. It has to perform many functions and duties of judicial and non-judicial nature. Let us start. Number 1. Original jurisdiction. Original jurisdiction means the cases that come directly to the High Court without being taken to any other court fall under original jurisdiction. A High Court has original jurisdiction in certain matters. Number 1. It has original jurisdiction over the matters relating to state revenue and its collection. Number 2. Cases related to violation of the fundamental rights, divorce, wills, and laws relating to marriage can be brought directly to a High Court. Violation of the fundamental rights and when the High Court issue the writs and what are writs, we will study a little later in this video. Before that, let us study the other powers of the High Court, like the appellate jurisdiction of the High Court. All the decisions made by the subordinate courts in all types of civil as well as criminal matters can be brought to the High Court by an appeal. Custodian of the Constitution. Just like the Supreme Court, a High Court also performs the duty of upholding the Constitution. It has the power of judicial review, which means that the High Court can review a state law to establish its constitutionality. If it finds any law, executive order or any ordinance to be inconsistent with the provision of the Constitution, it can declare it null and void. Next power of the High Court is the Court of Record. All the decisions and decrees. Decrees is an official order that has the force of law, issued by the High Court are printed and are kept as a record for future references by the courts as well as by the lawyers, if such a need arises. Thus, a High Court also acts as a court of record. Next is Revisory Jurisdiction of the High Court. The High Court has the power and the right to revise its earlier decisions and give a new decision contrary to earlier one. This provision is given as human judgment is fallible and an enormous judgment cannot be allowed to continue indefinitely. Fallible means capable of making mistakes or being wrong. Moreover, situations may arise in future requiring reconsideration of an earlier judgment. Page number 155 of your book, children. Keeping in mind the explanation we have done, let us read the jurisdiction, powers and functions of the High Court. Original jurisdiction. The High Court exercises original jurisdiction in cases that involve violation of fundamental rights and also the cases that involve a disagreement over matters related to state elections. Next is appellate jurisdiction. The civil and criminal cases that are brought in appeal against the decisions of lower courts come under appellate jurisdiction of the High Courts. Next, Supervisory jurisdiction. The high courts exercise supervisory jurisdiction over all the subordinate courts. A high court is responsible for the administration of its own affairs as well as for the affairs of its subordinate courts. It regulates the appointments of the subordinate services other than law services in the subordinate courts, and also possesses the power to issue orders to its subordinate courts in the interest of better judicial service to the people. It exercises supervision over all the courts and tribunals throughout the territories falling under its jurisdiction. Next, revisory jurisdiction. This jurisdiction is exercised in cases where the lower courts have gone beyond their jurisdiction, which means the High Court can review the verdict of the subordinate court for cases where it finds that the latter has exceeded its limit of jurisdiction or not followed the appropriate procedure. In such cases, the High Court takes further actions to rectify, means to correct the systematic discrepancy, means an illogical or surprising lack of compatibility. Now let us see that how high courts act as a guardian of the fundamental rights and issue the writs. The high courts also function as guardians of the fundamental rights of the Indian citizens. They protect the fundamental rights from being eroded, that is gradually destroyed, infringed means actively breaks the terms of law, and abridged to reduce or lessen in duration by any individual, a group of individual, or the state itself. They can issue different writs to the offending party or parties. What is the meaning of writ? Anything that is issued under an authority is a writ. Orders, warrants, directions, etc. issued under authority are example of writs. There are 5 major types of writs, and they are: number 1, habeas corpus; number 2, writ of mandamus; number 3, prohibition; number 4, certiorari; number 5, quo warranto. Each of them has different meanings and different implications. In India, both Supreme Court and High Court have been empowered with writ jurisdiction. They are the written order from the Supreme Court or High Court that commands constitutional remedies for Indian citizens against the violation of their fundamental rights. Article 32 in the Indian Constitution deals with the constitutional remedies that an Indian citizen can seek from the Supreme Court and High Court against the violation of his or her fundamental rights. The same article gives the Supreme Court power to issue writs for the enforcement of rights, whereas the High Court has the same power under the Article 226. The Latin meaning of the word habeas corpus is to have the body of. This writ is used to enforce the fundamental right of individual liberty against unlawful detention. Detention means to arrest or to be in custody. Through habeas corpus, Supreme Court or High Court orders one person who has arrested the another person to bring the body of the latter before the court. The court then examines the reason of his detention, and if there is no legal justification of his arrest, then he can be set free. Such a writ can be issued in such cases: number 1, when the person is arrested without any violation of a law; number 2, when the person is detained and not produced before the magistrate within 24 hours; number 3, when a person is arrested under a law which is unconstitutional. A magistrate is a civil officer who administers the law. There is a difference between judges and the magistrates. Judges generally hear larger, more complex cases, while magistrates hear smaller matters like petty crimes and traffic offences, etc. A general rule of filing the petition is that a person whose right has been infringed must file a petition. But habeas corpus is an exception, and anybody on behalf of the detainee is a person held in custody, especially for political reasons. So anyone on behalf of the detainee can file a petition. This writ can be issued against both public authorities as well as individuals. Mandamus. Mandamus means we command. This writ is a command issued by court to a public official or a public body, corporation, inferior court, asking them to perform their duties which they have refused to perform. Due to this, mandamus is called a wakening call, and it awakes the sleeping authorities to perform their duty. Mandamus cannot be issued against the following, and they are: number 1, a private individual or private body; against president or governors of the state; against a working chief justice. A petition for writ of mandamus can be filed by any person who seeks legal duty to be performed by a person or a body. Such a filing person must have real or special interest in the subject matter and must have legal right to do so. Next writ is the writ of prohibition. Prohibition means action of forbidding something, especially by law. The writ of prohibition means that the Supreme Court and High Courts may prohibit the lower courts, such as special tribunals. Tribunals are a court of justice, and magistrate courts. Magistrate courts are court having limited jurisdiction over minor civil and criminal matters, and other judiciary officers who are doing something which exceeds to their jurisdiction or acting contrary to the rule of natural justice. In other words, a court that is higher in position issues a prohibition writ against a court that is lower in position to prevent the latter from exceeding its jurisdiction. It cannot be issued against administrative authorities, legislative bodies, and private individuals or bodies. Next, writ of certiorari. Certiorari means to certify. It is a writ that orders to move a petition from an inferior court to superior court. It is issued by a higher court to a lower court. This writ can be issued by the Supreme Court or any high court for quashing, means to reject or to put an end to the order already passed by an inferior court. In other words, while the prohibition is available at the earlier stage, certiorari is available on similar grounds at a later stage. It is also said that the writ of prohibition is available during the tendency of proceedings before a subordinate court. Certiorari can be resorted to only after the order or decision has been announced. It is issued on the grounds of an excess of jurisdiction or lack of jurisdiction or error of law. It not only prevents but also cures for the mistakes in the judiciary. One point is to be noticed that the writ of certiorari cannot be issued against legislative bodies and private individuals or bodies. It is only issued from a higher court to a lower court. The next and the last writ is writ of quo warranto. The word quo warranto literally means on what authority one is holding the public office, or by what authority or warrant. It is a writ issued with a view to restraining a person from acting in a public office to which he is not entitled. The writ of quo warranto is used to prevent illegal assumption of any public office. Through this writ, the court inquires into the legality of a claim of a person to a public office. For example, a person of 62 years has been appointed to fill a public office, whereas the retirement age is 60 years. Now, the appropriate High Court has a right to issue a writ of quo warranto against the person and declare the office vacant. This writ cannot be issued against private or ministerial office. Journal facts about writs in India. Article 32 also empowers Parliament to authorize any other court to issue these writs. Before 1950, only the High Courts of Calcutta, Bombay, and Madras had the power to issue the writs. Article 226 empowers all the High Courts of India to issue the writs. Writs of India are borrowed from English law, where they are known as prerogative writs. Page number 155, let us do the reading of writs. A writ is a formal written order issued by a court, Supreme Court and High Courts of India, that requires specific action by the person or entity to whom the writ is directed. Warrants, orders, and directions are a few examples of writ. Warrants is a document issued by a legal or government official authorizing the police to make an arrest. Types of writs. Writs of habeas corpus means you may have the body. This writ is issued to produce a person physically before the court. Next, Writ of certiorari means to be certified. This writ is issued to a lower court directing that the records of a case is to be sent to a higher court. Next, writ of quo warranto means of what warrants or what is your authority. This is issued to a person or authority to explain to the court by what authority he holds the office. Next, writ of mandamus means we command. This issue a command to a lower court or person to perform a public or statutory duty. It means a lawful duty. That is it for the today's class. Let us see the objectives that we have covered. We have studied about the High Court, its jurisdiction powers and functions, original jurisdiction, appellate jurisdiction, supervisory, revisory jurisdiction, and we have studied about the writs and the types of writs. Now you have to do the reading on page 154 and 155, solve the related back exercises, revise the important terms like original jurisdiction, appellate jurisdiction, court of record, judicial review, and there are so many other terms in the chapter. Follow us on YouTube. Take care of yourself. Bye.